I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Courts, take it again. Count 1. Registrar, after it, did you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asking, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 that I read to you? Defendant responded, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agabi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section.
So that was Omotosho, proving to us that Nnamdi Kanu understood the charges against him. Now let me explain this again, just in case if you didn't understand me the last time. Nigeria says they have case against Nnamdi Kanu. And the case against him, which started with treason, has now changed to terrorism. Now, they've presented what should have been their case and their evidence. There is no single physical evidence against Nnamdi Kanu, except that he broadcasted, he said, and they were quoting things he said as it suits them as their evidence against him. And the judge said, these are incontrovertible evidence, which means they are evidence that you cannot even dispute. Okay, these are your evidence. Good. Now, let's start with the charges. On what law did you bring about these charges? So that I can see if they are relative, so that whenever I'm going to defend myself, I know that you are charging me based on this law, not what you are charging me about, on this law. So that if I am convicted, this will be my punishment. I need that. That has not been cited since this whole thing started. And I'm pointing it out now. So if there's anything at all, it should be for them to go and amend their own case, amend their charges. But they didn't. They went on. Now, in law, there's something called rule of law. Rule of law means laws that is written in that plain sentence can mean many things. That's why you have the rules of law. Rules means as this thing is written, it doesn't matter how it sounds to you. The interpretation of it remains the same, not what you interpret it as. So because of that, right, everybody should follow it. So show me this. Then after that, I will put up my defense against your allegation. You stole my wristwatch. You borrowed money from me, you didn't pay. Oh, you backbite me. All those things, right? Those are your allegations, right? Good. Now I will address them one after the other. Okay? So that the judge will then say, this is my defense, this is my own defense, right? These are the charges and allegations against me presented before the judge. That is what is called fair hearing. Nnamdi Kanu never got any of that. For your information, all these years that Nnamdi Kanu had all these best brains as lawyers, the DSS has become so powerful that even when the court granted Nnamdi Kanu access, that he should be allowed to have access to his own legal team, discuss his own case. Oh, yeah, they granted him access to his legal team. But did they allow them to actually have proper conversation, written conversations, and the rest of that? No. They were not allowed to go in with electronics. They are not allowed to go in with a paper or pen. They were just allowed to go in there and have conversation, fully monitored, with about 4 cameras in a room, all of them, right, capturing every verbal thing they say. That's not fair hearing. So many other things that happened, though, that this same court ignored. That's not fair trial. Somebody is standing criminal. You don't understand criminal trial. It simply means, right, for fair hearing, he would have access to every material that he could use in defense of himself. But they didn't give him that. A lot of you are reading a lot of these junks in their media, all this rubbish that they are publishing. Nobody is actually asking the real question behind this whole thing. Not that Nnamdi Kanu doesn't want to defend himself. He's been defending himself, but most of the time, these guys have been running from their own court. And wherever the court gets, wherever the court caught up with them, they suddenly change the rule again. How is that fair? Somebody is being tried for something, is preparing for it, and the next day you switch, you changed it. Every now and then, because it is Nnamdi Kanu. So they may tell you that I made a mistake, whatever you even tell yourself, it doesn't matter. I'll keep reminding you that it will be a deranged person that will 100% expect justice from that their court. In this case, the double standard. His case is even like a double jeopardy. So one of the prosecution team, the lawyer, said that the court should ignore Nnamdi Kanu's stand or plea and all of that. They should go ahead and deliver judgment, which is what Omotosho is doing right now. But watch this.
Reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to are unknown to law. It is for your lordship to determine that in other ones. But the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay of proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect and we urge your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge your Lordship.
Nuisance, Lily.
That's Awomolo. Okay, so asking the courts to ignore those requests of Nnamdi Kanu and go ahead and deliver the judgments, which is exactly what Omotosho did. Now here we're going to get to the part where Omotosho started linking everything wrong with that contraption to Nnamdi Kanu. Yeah, it was practically blamed for Nigeria killing their own citizens during the NSAS, and then denied it. They denied that nobody died. So right now, is now being kind of like a blame for it. So many other things he was reading. So yeah, let's go listen to a few of them. Not all of them, because it was like about 2 hours long. So I've cut out a few that I think are relevant, right, to this conversation. Why we're also monitoring what is judgment going to be, like what is going to be Nnamdi Kanu sentencing to death, life imprisonment, 100 years in prison, and all of that based on non-existing law. Did you hear what Awomolo said there? That's Awomolo. Awomolo said, because when they were doing the trial, they asked Nnamdi Kanu, right, when they were reading his charges to him, that was he guilty or not? That Nnamdi Kanu already said he's not guilty. He's already taken a plea. Because he already took a plea, and now asking them that the law that they are trying him on should be proven. That simply means that it is just a repetition. The court should ignore that. Nnamdi Kanu already pleaded not guilty, which means the court has recorded his plea. So that there is no law that backs it, or whatever that he's saying, the court should ignore it. They should ignore that. That's what he was saying in that video. And that's exactly, like I said, what Omotosho did. Reading his judgment according to him, and why Nnamdi Kanu is guilty of this or guilty of that. Let's take them one after the other. Watch this.
Declaration of a sit at home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved CONT 2 beyond reasonable doubt. Consequently, the defendant is hereby convicted of CONT 2. Is that beginning from the commencement date of 28th September, if you go there and negotiate any other thing apart from Biafra, you better not come back, because our people will be waiting for you, that very person, unquote. When he was asked about the consequence for this representative, including one Ike Nwanchuku, defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people don't understand. Lugard killed many people to put Nigeria together, and the killing of people to disintegrate the zoo shouldn't come to anybody as a surprise. Our promise is very simple. If they fail to give us Biafra, Somalia will look like a paradise compared to what will happen to the zoo. It is a promise. It is a pledge. Also a threat to them. They must understand it, that we have had enough of this nonsense. Unquote. It is not noteworthy that defendants in the said interview kept referring to the southeastern part of Nigeria as Biafra. The defendants made some comments, such as the governor of the southeastern state being the stooge of Hausa Fulani godfathers. He even stated that Rochas Okorocha, former governor of Imo, had instrumentalized the entire state to satisfy his Hausa Fulani godfather. He said nobody had asked Governor Peter Obi about Izu River and the person dumped in the said river. Further, during the interview, defendants, while answering a question about whether he will embrace a peace separation or choose a violent path, stated at about 7 minutes 30 second mark of Sahara TV interview in Exhibit PWW, which is a flash drive containing all its broadcasts, said, and I quote, "If they do not give us Biafra, there will be nothing living in that very zoo called Nigeria. Nothing will survive there, I can assure you," unquote. He also made reference to the Nigeria Civil War when he said, in 1967 to 1970, it's not 2010 to 2015. Then we had scientists, but now we have people who can make things happen even better than what we had in the late 60s. So that should ring a warning that we are not joking. 8 minutes mark in the flash. He said, "I do not believe in peaceful actualization of whatever rubbish is called. I have never seen where you will become free by peaceful means," unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained in Exhibit PWW, the defendants in the beginning of the broadcast stated thus: "My name is Mazi Nnamdi Kanu. I am the leader of indigenous people of Biafra, IPOB, and director of Radio Biafra and Biafra Television. I will remain a loyal servant of the people of Biafra." He further stated around 51 minutes mark, and I quote, "If God is on our side, which I know He is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come. I want to let Katrina Langs and the British government to know that we have chosen the path of death, and people are dying every day.